Premarital Cohabitation and Property Division for Same-Sex Couples in New York. For same-sex couples in New York, the rules around property division in divorce carry a painful irony that straight couples have never had to face. New York courts generally treat property acquired before marriage as separate property, meaning it belongs solely to the spouse who originally acquired it. But many same-sex partners spent years, sometimes decades, building a shared financial life together long before marriage was even legally available to them. Under New York Domestic Relations Law, Section 236(b), the date of legal marriage is the default starting point for classifying whether property is marital or separate. New York began licensing same-sex marriages on July 24, 2011, when the Marriage Equality Act took effect, and the Supreme Court's Obergefell decision extended that right nationwide in 2015. This means that a same-sex couple who lived together for 15 years before 2011 had no legal choice but to remain unmarried. Yet the law treats their premarital contributions the same as any other. This window of time between when a couple began living together and when they could legally marry is known as the cohabitation gap, and it has real financial consequences in divorce. Contributions made before the legal marriage date, including mortgage payments, joint investments, and shared business building, generally fall outside the marital estate. However, commingling, which occurs when separate and marital funds are mixed together, can change that outcome by causing premarital assets to lose their protected status. Depositing premarital savings into a joint account, adding a spouse to a property deed, or paying a premarital mortgage with marital earnings are all actions that can trigger commingling disputes. When a spouse claims a commingled asset is still separate property, they bear the burden of proving its original source with reliable evidence such as bank records and financial documentation. For same-sex couples who shared finances seamlessly for years before and after marriage, this tracing process can be extraordinarily complex and high stakes. Other legal theories, such as contractual rights or active appreciation of separate property during the marriage, may also affect how premarital assets are ultimately classified and divided. Having an experienced attorney who understands the unique intersection of same-sex relationship history and New York property law is essential to protecting your financial interests. Contact Juan Luciano Divorce Lawyer, located at 187 East 163rd Street, Bronx, New York 10451, by calling 718-519-8336 to schedule a consultation with a lawyer who handles same-sex divorce and property division across the Bronx and New York City.